afternoon. My name is Christopher Sands, and I'm a senior fellow at the Hudson Institute, and it's my really great honor to have not only listened to 3 days of terrific presentations, but to now be able to moderate what will be the grand finale, the big wrap-up panel that will try to put into perspective some of what you've seen and heard in previous panels. Those of you who watched the Winter Olympics will remember that in the closing ceremonies there was this cavalcade of Canadian celebrities, and it started with William Shatner giving a kind of loopy, sort of comedic opening that then set the tone for the rest of the surreal presentations that followed. And that's sort of my role. The William Shatner role is set in motion a cavalcade of Canada-U.S. Law Institute celebrities, people who have been well involved with this organization for a long time, who are well involved in the issues of Canada-U.S. law, and who will bring their perspectives to what we've heard as well. Let me briefly give introductions for people who need no introductions here, who are on this final panel. Don Cameron is with he's the practice group leader for the international trade at Troutman Sanders LLP in Washington, D.C. Next to him, Jim McElroy is Counsel of Public Policy at McElroy in Toronto. Larry Herman is a partner at Castles Brock and Blackwell in Toronto. Michael Robinson is counsel at Fasken Martineau Dumoulin, also in their Toronto office. And at the very end of the row, Rick Newcomb is the chair of the International Trade Practice Group and a partner at DLA Piper LLP in Washington, D.C. I'm going to make a few contextual remarks and a bit of a summary, and then I'll take this handy microphone and we'll pass it along to give each of the gentlemen a chance to comment. Just sort of as a general observation, one of the rules you learn early on about political economy is that as people become wealthier, they become much more insistent on having a voice in the governance of the transactions that have made them wealthy. It's very logical. But you want to have a say in the rules that affect your livelihood. And the wealthier you are, the better you have a means to insist and make sure that governance systems and governments respond to you. This is an old human problem of the way in which we organize ourselves. This was a problem in the Roman Empire. As Egypt and Byzantium became wealthy, they wanted a say in the politics of Rome. Those of you, since we're in an Anglo-American tradition here, will remember that while we think of the Magna Carta as a foundational document in law, it came because of the wealth of barons versus the wealth of kings and the desire to have a say in the way in which England was governed. The American Revolution, as the 13 colonies south of here, along the eastern seaboard, became wealthier and wealthier, they wanted, as Englishmen, seats in Parliament. And when they didn't get them, we had a revolution to change the rules. And Canada, as it stayed loyal to the British Empire, nonetheless, as the Canadian colonies became wealthier and wealthier, Canadians insisted in a voice in the management of the empire. First through imperial councils, and later in dialogue with Great Britain, whether it was over the Corn Laws or some other issue, including the issues of when to go to war. So this problem has been with us for a long time, is very human, and now we face it here in North America, between Canada and the United States. And let me just say one more global comment. It is not coincidental that we have seen in this world a great spread of democracy as a means of governance around the world, multiplying more and more countries that have democratic or quasi-democratic systems, as we've seen wealth and prosperity grow from one side of the world to the other. So increasingly, we see the connection between the two. And globalization, or at least in our local sense, in our North American sense, deepening economic integration, is moving faster than the governance mechanisms we set up to manage those transaction flows. And we've heard that again and again in different ways in these panels. And so what happens when that happens, again as we've seen in the last few days, is that we fall back on the law to reconcile differing systems of governance to try to allow the flows to continue in, as best as possible, a rule of law consistent way. And that's why the Canada-U.S. Law Institute and its work is so essential. Because right now, there is no overarching Canada-U.S. governance for what is increasingly a shared economy. and yet we do have a lot of work sorting out the gaps and the differences in our governance systems to allow that integration to continue to deepen. Listening to some of the discussion that we've heard so far, and this is a bit of a clumping of things, but I would argue that what we've seen are 4 types of governance that are coexisting and attempting to give structure to the flows that are going back and forth, the economic flows that are shaping our integration between the United States and Canada. The first and the most logical place to begin are federal to federal governance arrangements. And most notably, these include the Canada-U.S. Free Trade Agreement, NAFTA, but also, as we heard earlier this morning, tax treaties designed to govern the way in which we manage taxation, intellectual property rights, which we had a panel on, and some of the border security arrangements that do bring us back to federal control of national borders. Secondly, we see the emergence of an interesting area that came up in the first panel yesterday of state and provincial interactions, particularly in the area of environmental climate change policy, where you're seeing the Western Climate Initiative, which of course includes not only Western U.S. states but Canadian members, the Regional Greenhouse Gas Initiative in the East, and other organizations among states and provinces attempting to deal with carbon trading, not only across a broad region, but among these different jurisdictions to deal with the climate problem. A third area that we heard about is the private-to-private interaction. That is to say, where businesses working together try to find rules. And the most notable example of that was the example of United Laboratories, Canadian Standards Association, trying to create baseline reconciliations of the national systems that we have for governing engineering standards, safety standards, reconciliations that don't trump what the governments do, but try to provide business with a clear set of operational, testable standards for product safety that will give them the ability to produce a product that works in multiple markets. So it doesn't supersede government, but makes government work more effectively by building a bridge between them. But perhaps the most fascinating area for me, and one that I think we saw a number of the panels touch on, and there's a reason for that, I think because it is a growing area of concern, is the public-private partnership for the governance of these transactions. Public-private because the private sector has a good window on what's needed, and the public sector nonetheless has the authority to provide the governance. And so the two work together. Examples we heard from on food safety, where we heard that it was groups providing supply chain verification of the safety of food, but testing was done by government agencies. The auto industry, where the technical challenges of building a car that is green or building a car that meets fuel efficiency standards are such that there needs to be a dialogue between the governments in this case, and the industry to figure out how to effectively reach public good goals. Data protection and privacy, where companies are doing their best to protect data, obviously for reasons not just of liability, but of concern for their clients and their employees, but trying to find ways to make sure that can be verified with a minimum of intrusion by governments in a way that allows them to move data and manage a multinational or transnational enterprise. Tax treaties that fall back on business to help them to figure out things like transfer pricing. Impossible necessarily to settle outside, but as we heard this morning, the challenge of transfer pricing with advanced pricing arrangements to make it a little easier to figure out what is fair price for goods, a growing concern. And as we heard in the last panel, programs like the Customs Trade Partnership against Terrorism, Partners in Protection, programs designed to build a partnership between the private sector, which manages security across the supply chain, and the public sector, which has to use that information to hopefully expedite the secure passage of goods across our border. And with new areas like 10+2 in terms of data sharing, we're moving even further down this road. All of this interaction and attempts to establish governance between these two countries, between the jurisdictions involved, to manage the deepening integration, to me raises a couple of broad questions that I think this panel is very well suited to begin to address. First, remember that the conference title that we've been working under here is the Canada-U.S. Regulatory Regime Review, and they've certainly done that, reform, and we'd like to point to some directions that reform might go, and recovery, how we can facilitate an economic recovery for all of us, and a recovery for those of us who remember the pre-2001 border and the relationships we'd established, a recovery of some of the best of our cooperative tradition. So some questions that this raises for me. First, how can the law be adapted, extended, and refined, the law that we have today, to provide adequate governance for today's integration? What can we do to reform the current laws on the books in their application, administration, and function to make them work better? We've heard a number of suggestions that I think fall into that basket. Secondly, what role should be played as we move forward to adapt additional governance by legislatures, federal, Parliament, and Congress, but also state and provincial? What role should those legislatures play? What role should judiciaries play? And we heard a little bit about, in the area of data privacy, some of what had come through judge-made law in a panel yesterday that was providing a framework that many people felt was at least good, but not as good as if the legislature had opined. And what role should be played by administrative agencies? Remember in our discussion on the environment, we talked about the role the EPA might play as a proactive player in establishing emissions rules affecting our future energy development. But there are other areas in which administrative agencies providing a framework on their own might provide the best vehicle, or perhaps because of their relative lack of accountability compared to the legislature, they would be inappropriate to proceed on that basis, and we prefer to see a different debate. A third question. Since the realities of integration, as I mentioned earlier, are most easily seen and experienced in the private sector, how can the private sector initiate public-private partnership? Is there a way for the private sector, not just one firm, but perhaps through industry associations or firms that happen even as competitors to recognize a common problem, begin the process of engaging the public sector in both countries without this becoming a huge process of talking to 20 people before you can proceed? How can we empower the private sector to initiate? How could the private sector do a better job of initiating the need for reform, or even revolution? If we totally need to scrap the current system and reform it, how do we get the private sector to take the lead here? What do we need to do to empower them? And is it possible, this is my fourth observation, that our current systems, even with an increased public-private partnership in rewriting rules and refining rules and providing new systems, is it possible that these systems will prove inadequate? At the extreme end, we could talk about a common governance for this economy, one in which the United States and Canada would somehow work together. Canada is the 51st state or set of states, something that we all joke about, but it does seem to be a logic that integration points to, the need for a common governance. Or perhaps, as Europe has it, a North American governance panel, or a North American commission, a North American parliament. Are those ideas, once thought to be fanciful at the extreme end of the debate, coming into play? Or will we find that we can work short of those revolutions to make the system, with two large federal governments managing it for us, work? Do we need a big vision, as many people in the Canada-U.S. relationship talk about, or can we incrementally improve the management of this relationship sufficient to facilitate the deepening integration that we're seeing? And I suppose there is a broader question, which is, failing all of this, will the deepening integration that we've seen continue in the future? Or have we hit the high point already? And the future involves, as some people have suggested, greater trade with China, greater trade with Europe, but diminished trade between Canada and the U.S. because we have failed to answer these questions adequately. Whether it was through a lack of ambition, a failure of nerve to ask tough questions, or really just that we have one of the most convoluted systems of governance, or as David Funk suggested, we're the stupidest people on earth, and therefore we can't resolve these problems on our own. Now, I have a panel today of not the stupidest people on earth, some of the smartest people on earth, and I want to turn it now to the panel to perhaps offer their quick reactions to my nonsense, or to move on to offer their own comments, looking at this from their expertise and reflecting on the panels that we've had. To make this simple, I have a microphone. This is also for our friends who are recording this. I'm going to hand it now to Don Cameron, and we'll let him pass it along as he would. Thanks very much.
Okay, well, you just passed it to the stupidest person on the panel. Following along with David's suggestion. That's really ambitious in terms of what you're talking about. When I look at this as a trade lawyer and what we see in Washington, you look at NAFTA. Why did NAFTA occur? NAFTA didn't occur because the governments thought that this is something that would develop the trade. NAFTA occurred to follow the trade. It was basically the economics did force it. So I guess I'm not as skeptical in the long term, but over the short term, I'm extremely skeptical in terms of where we are. We've got an administration right now. You have an Undersecretary of Commerce for international trade that was just appointed 2 weeks ago. There is still no Assistant Secretary for Import Administration. Now, exactly how is it that the Commerce Department is going to coordinate with the U.S. Trade Representative's Office for setting trade policy when there is no political direction within the Commerce Department? And I realize that this is a very, it's a somewhat of an inside baseball type of topic, but it does have real consequences, because when there is no political direction, then you have individual offices that are acting independently, and there is no policy guidance. And as a result, you have chaos. And trying to tell clients about why there is chaos, the only thing I can tell our clients is that's the reason we have the courts. And that's not really a very satisfactory answer. But that is the sort of thing that we're dealing with right now in Washington. You talk about legislatures. Think about this in terms of the current political climate. I mean, I realize we're talking about the increase in exports. Well, I fully expect there to be an increase in exports, but it's not going to be because of anything that anybody in government is doing about it. There's no Doha round. That's not going to be concluded. We're not concluding any FTA agreements that would actually have a very tangible benefit in terms of increasing our exports. None of that's going to happen because there is no political will within Congress to get that to happen. And this administration, let's be honest, trade is not the priority. Recovery is a priority. Exports are important, but exports are going to come because of the private sector. They are not going to come as a result of the government. And think about what you wish for before you get it. Do you really want trade legislation before this Congress? I would suggest to you that it would be a nightmare. Now, this is not a Republican-Democrat issue. This is the politics of trade. And right now, people are scared. And when people are scared, the legislatures do not act in the best interests of the country in one sense. This is the reason that you have reactions against FTAs, even if you can actually point to evidence that the FTA, contrary to the great sucking sound that we heard from Ross Perot, will actually give you a $10 billion export surplus in terms of trade benefit. But no, we're not going to even touch that, at least until after the midterm election. So that's my 2 cents worth on this stuff. I think that in the immediate term, as we're still emerging from a very horrible economic experience, and let's all remember what it was around this time last year when we were talking about the economy. I mean, people were still talking about using the word depression. And you can say what you will about the economy now, we're not talking that way. And that actually is a good thing. But we still have a ways to go before we start getting some real perspective, I think, in terms of if you really want to go to the legislature and do something. Anyway, that's my 2 cents.
Well done.
Thank you very much. Don's always a hard act to follow. My name is Jim McElroy. I'm an international trade lawyer, and I'm based in Toronto. And I'd like to follow on what both Chris and Don mentioned, and that is, what is the role of treaties and what is the role in national governments? Because we traditionally look to them to drive this kind of process. And one thing that really struck me yesterday morning was when Professor Maureen Irish was discussing the North American Free Trade Agreement, and she took us through all the provisions on technical barriers to trade, and she showed us all these provisions that had the word shall in it, and yet 15 years later, nothing's happened. I mean, we have this tremendous treaty, it's got great language in it, but we're still here today talking about regulatory differences. And I guess the first question you have to ask yourself is, why do we care about regulatory differences? I mean, who cares? Well, we should care because they create barriers to trade and they add costs and burdens, particularly on small and medium-sized businesses. And they decrease our ability to compete, North American companies to compete in the global economy. And we've got to do something about them. But I think before we do something about them, we have to recognize that we always use the word technical regulations. This is not a technical problem. This involves very emotional debates about national sovereignty. Many people think it's a zero-sum game. If we have common regulations with the United States, that means we've lost. Canada's given up its sovereignty. The other part of it is, in addition to this loss of national sovereignty, people think that this is a plot by big, bad multinational corporations. The private sector is taking over the public interest. So we have to recognize this is a very loaded debate, and if we treat it as just a simple technical debate, we're going to lose it, because the unions and others, in Canada we have somebody, Maud Barlow, the Council of Canadians, the sky is falling every time we harmonize a Canadian regulation with an American regulation. By definition, it's bad. By definition, it was forced upon us. By definition, we've been diminished. That's the way they portray it, and we have to recognize that. I want to just talk about what I call top-down, where you have lofty treaties like the NAFTA and lofty statements from President Obama and our Prime Minister, Stephen Harper, and the President of Mexico. In August of 2007, they met in Montebello, Canada, and the leaders endorsed this thing called a Regulatory Cooperation Framework. This is 3 years ago, but nothing's happened. And so they met again in Guadalajara, Mexico, last August, and they said, and I'll read it to you, "We commend the progress achieved on reducing unnecessary regulatory differences and have instructed our respective ministers to continue this work by building on the previous efforts, developing focused priorities and a specific timeline." To me, that is saying, listen, we talked about this 3 years ago, nothing's happened, we got to try something new. Let me conclude by just discussing a couple of events that occurred over the last couple of weeks that give me reason to be optimistic. First of all, there was a press release issued by Environment Canada on April the 1st, and it says, "Canada and the U.S. announce common standards for regulating greenhouse gas emissions from new vehicles." This is a positive development. I think one thing that's important is it points out that climate change is going to be driving regulatory cooperation. It's the big issue, it's the one that's biting them, and you're going to see climate change driving it. And I think that you heard that from both Minister Peterson and Governor Blanchard at the opening session, when we said, what's the big issue? What's going to drive the Canada-United States relationship? And it is climate change. It's big, and it's going to make things happen. As a Canadian, I have to tell you, I'd rather see climate change driving the bus on the relationship than security. I'm tired of security. It's all about borders, and you know, it is really poisoning the relationship. Whereas I think climate change is something that we can work together on. What that press release said is Canada will harmonize its regulations with the mandatory national standards of the U.S. beginning with the 2011 model year. And I think that's important because we've decided we're going to harmonize climate change action on a North American scale. Remember one thing here. This isn't NAFTA. This is Canada and U.S. You don't see Mexico here. And you're going to see more and more this is bilaterally driven. I think it's also important that, you know, as I said, critics are going to say, this is bad, Canada's aping the Americans, this is terrible, we're adopting the American approach. My question is, what is the American approach? We saw yesterday, we saw Mayor Fickling show us all of these pieces of legislation swirling around in the U.S. Congress. Nobody knows what's going to come out of there. And I think that's something that we have to watch. But just to finish off on this press release, what I found fascinating is it came out of California, came out of a state, not out of Washington, and then a province picked up on it, Quebec. They started pressuring Ottawa. And then you saw the industry, particularly Ford, saying, we've got to have North American standards. What does that tell me? It's bottom up. It's industry driven. It's coming out of the states. It's coming out of the provinces. And the capitals are not proactive. The capitals are reacting. They're behind the ball on this. And I think they're going to continue to be behind on the ball on this. I want to conclude by mentioning something that appeared in the Canada Gazette, which is, it's like the U.S. Register. That's where governments publish what they're going to do. And they published a notice, the Department of Foreign Affairs and International Trade published a notice on March 20th, and it's called Request for Public Comments on Future Areas for North American Regulatory Cooperation. I have to tell you, North American regulatory cooperation is a better buzzword than harmonization or convergence because it gets away from this idea. Harmonization means the little guy has to follow the big guy, whereas this regulatory cooperation, I think it's got a better buzz. But what's going on here is this is bottom up. The government is basically saying, we don't know what to do. We want you, the private sector, to tell us what to do. And it's interesting that Ottawa is encouraging Canadian, American, and Mexican stakeholders to develop joint submissions. And I go back to what Chris was saying, you know, what can the private sector be doing? I think they have to be trying to work together and going to their respective national governments saying, we've worked out the details, we agree on this. And I suspect that's what's happened with these vehicle emissions. I think the big three worked it out and they went forward. I just want to finish off by saying that I think you're going to see more bottom-up and less top-down. I think that by top-down I mean the national governments, Ottawa and Washington. And the reason for that is twofold. First of all, technology is moving way too fast for bureaucrats to keep up with it. They just can't keep up. Try to keep up with Dr. Fung. You can't keep up. The second thing is that I think governments, they're broke. They don't have the resources. They don't have the sectoral expertise. And I think what you're going to gradually see is that the public service is going to decline. You're going to see, we've already seen wage freezes, you're going to see hiring freezes, and you're going to see attrition. So I'll just close off by saying that the top-down approach has not worked. We've had NAFTA for 15 years. We had this announcement in 2007, and we've had this announcement in 2010, but now we see the Gazette notice saying we want bottom-up participation. I think nature abhors a vacuum. It's going to happen, but it's not going to come out of us watching Washington or watching Ottawa. The bottom line is the private sector is proactive, the public sector is reactive. And we as an institute should be hitching our wagon to the proactive element. Thank you very much.
What can you say after that? And after Chris Sand's incredibly thorough and helpful introduction. Chris, if you haven't read the paper that he did last year for the Brookings Institution, not his own institution, friendly neighboring institution, it's in your material. It's an excellent study of all of the challenges at the border and possible solutions. Chris and I differ on one important thing that I'm going to come to in a moment, but I commend the excellent work that he's done. In fact, while I'm on the point, he's one of the most knowledgeable Americans about the Canada-U.S. relationship that you can find, and it's very gratifying that he's here with us today.
Here, here.
Here's what here's what I have picked up from the discussion over the last day and a half. Just to summarize, firstly, that there are a lot of regulatory challenges and divergences that are inhibiting the realization of all the benefits that the NAFTA provides. You know, the free trade deal is a done deal. It's done, and the challenges are to maintain the benefits of the free trade agreement. And what we found is that regulatory differences of all sorts, certification differences and divergencies in approach to regulations are an inhibiting factor. So I think that's a given. We heard a lot of sectoral discussions over the last day and a half that point that out, showing where the border in one way or another still exists and inhibits free trade between the two countries. So that's the first thing. The second point, and here's where Chris and I differ to some extent in a friendly way. I pick up the conclusion that the challenges have to be addressed on a bilateral basis between Canada and the United States. Now, Chris he's an optimist and an idealist, and he believes in a trilateral approach to these things, and we've had a long discussion over various parts of these differences, but I think what we heard today is that Canada and the United States can have a lot of reason for solving these on a bilateral basis, not on a trilateral basis. And I think that's correct. Border issues particularly, but other things as well. Regulatory reform and recovery is what we're talking about, and I believe that has to be done bilaterally. And the third thing that I thought was really fascinating in the discussion over the last day and a half was that the private sector, and Jim McElroy's picked up the point, the private sector is moving ahead of governments. In other words, we have the private sector determining how goods can be certified for purposes of entering the market. CSA and UL certification, and there are a lot of other things, ASTM, ASME. These are all private sector bodies that certify products. And no one will buy those products. They won't be shipped across the border unless they have those private sector specifications certified on the product. This is a fascinating development, and one that I think that we could, in the Institute, look at more closely. But the private sector is ahead of where the governments are. And then the final point, which relates to some of the first 3 points, the final point, I think, that's emerged from the discussion is that while we have the NAFTA, and we have a number of political declarations, and we have all kinds of working arrangements between the two countries, a multitude of working arrangements. I think the School of Public Service did a study, which you're well aware of, and they pointed out that there are, I think, 360 MOUs, executive agreements, treaties, etc., but very few overarching agreements. Very, very few. In fact, surprisingly few overarching treaties, the NAFTA being one, and there's a handful of others between our two countries, which is rather surprising. But what I pick up from the discussion is that there really isn't a adequate institutional capacity between the two countries to deal with the regulatory issues. There are, as I said, a lot of working arrangements, but there's no institutional capacity. It strikes me as a great gap in the relationship that we don't have, other than NAFTA working groups, which have not proceeded very far, but we don't have an overarching structure to deal with this very important issue of regulatory reform. Not necessarily to harmonize, but to ensure that there is at least appropriate recognition of certifications, private sector and public sector certifications on both sides of the border. The problem is a large one. I'm not sure, Dan, that this is the next big issue. But it certainly is an issue emerging from the discussions over the last day and a half. It certainly is an issue that needs addressing. The lack of institutional capacity to deal with the regulatory barriers to the realization of all the benefits that the NAFTA was supposed to provide.
Thanks, Larry. 2 words to solve about a third of the problem. Customs union. It would also save me from having to teach the rules of origin in my NAFTA course, which I've never understood. I tried to get Johnny Johnson, who's I think the only Canadian who does, to come up and teach the class. But I know from listening to Johnny that even though he's very smart, the students would never understand him because I can't. They're all so hideously complicated. But surely that gets rid of a lot of the nonsense. And I've never heard any economist or politician at this stage, after we lived with NAFTA and, of course, Canada-U.S. free trade agreement before that for so long, come up with any valid reason why we shouldn't move now to a customs union. Okay.
Selective listening.
Selective what?
Listening.
Selective listening. Okay. I have something I can disagree with Larry. Larry and I love to disagree. We do it a lot. He's a grit, and I started out as a Tory.
You're not supposed to disclose my secret.
Oh, so everybody knows. Until those Western guys sort of hijacked my progressive conservative party, and now I sort of float back and forth. But I disagree with Larry on UL and CSA, and I think it's an example of how the thing hasn't worked. I'm on Jim's side on that. I was asked by the minister of, by DFAID, I guess, to go to Guadalajara in 1996. And believe it or not, there was the 3rd tripartite conference on bringing all of our regulatory and licensing and whatever structures together. And I got this sort of last minute notice. I didn't know what it was all about. Went off to Guadalajara. We drank a lot of tequila, and there were a lot of bureaucrats down there and a few academics. And I was supposed to report on the progress. And as I said to my group, dealing with mutual recognitions of professional and labor standards, this is going to be a very short presentation. You know, the architects and the engineers who work with things that don't recognize borders have done a good job. Nobody else has. And why do we still have to put both of these stamps on every toaster that crosses the border? There should be one common set of these, and there should be a new acronym instead of US, UL, and CSA, and that should have disappeared 19 years ago. I don't think there's been much progress at all on that score. Now, there's something I don't think came up, except tangentially, during the last 2 days, and it's a really important thing in Canada, and I'd like you to all follow it in the press. The New York Times will be the only one that ever reports anything on Canada, but they'll probably pick up on it. The huge issue between Canada and the U.S. in terms of regulatory is competence. In Canada, the feds don't have it. In the U.S., you have it. We have a strange federalist...
You mean constitutional competence?
Yeah.
Not the other kind.
No, not the other kind, sorry. Competence to do things, to get these issues resolved. And I won't burden you with the background, although it is an embarrassing Canadian anecdote that the law was established by a bunch of lords of the Privy Council in 1937, which was then the highest court in the land for appeals in Canada, in something called the Labor Conventions case, in which they, all being, of course, lords of a jurisdiction that's unitary, that wouldn't know a federalist state if they tripped over it, they all said, well, we looked at the strange Canadian Constitution, and it seemed to say that these federal people can sign all these international treaties, But if they affect the provinces, all the provinces have to sign them too. And that's been the law in this country since 1937. The trade and commerce power, which I know Larry and many others believe, could blow that silly case out of the water in the 21st century, has not come up until now. And how does it come up? Well, of course, because it's a federal provincial issue with that famous La Belle Province, La Province de Quebec. And it concerns the Federal Securities Commission. We're finally getting the nerve to say we have to have one of these. This is ludicrous to have 13 jurisdictions governing our securities industry. So that's been pronounced as policy by the feds. Quebec immediately said, you can't do that. We're doing a constitutional reference in our Court of Appeal for Quebec. And the Court of Appeal for Quebec will say, that's unconstitutional. It will follow the Labor Convention's case from the Privy Council of 1937, and that'll be the end of you feds. The feds said, aha, you fell into the trap. You put the issue to the court system of Quebec. But we have the right, as the federal government, to put the issue to the Supreme Court of Canada. So the feds have stated the case, in effect, oversimplified. We can do this. And the heck with the Labor Convention case, and the trade and commerce power is going to be held in 2011 or whenever they get around to it by the Supreme Court of Canada to trump this ridiculous Labor Convention's case, and then we can get on with being able to, back to the quotidien issue of Canada-U.S. regulatory compliance, we can get back to the feds having power to do more things. So read your papers, watch that one, that's important.
Thank you.
Public-private partnerships versus reform. We have one. We're sitting here in it. Canada-U.S. Law Institute used to involve much more business from Canada and the U.S. And it's up to the core group, which is sitting here, the people which really appreciate this organization, to get our business clients more involved and continue the drive, which I agree with everybody is absolutely necessary, and which is well rolling along now, the drive to have the private sector push the governments ahead with regulatory reform. And now with our new co-chairs, nothing against Henry T. King of blessed memory, but these are people with new ideas and new directions who want to involve business, the two Jims, Blanchard and Peterson, and I think we can all assist by making this organization, which is unique. There is nothing between the U.S. and Canada like CUSLA. We can be the leader in this whole area going forward. But we need all you people to spread the gospel of CUSLA to your clients, your friends, and to people. We need more David funds here. And that's how we get public-private partnerships really rolling along. And I have one last point here. I don't think so. I think then you get that really tough job, because you have to do cleanup after we've taken all the good points. I'm going to pass it now to Richard.
Thank you all. Being cleanup for this group does pose its challenge, because most of the good points have been made. And I don't think I disagree with any of these. I was particularly pleased by Jessica's panel about issues relating to the northern border and how should it be governed, and how is it different from the southern border. Throughout my lifetime, the U.S. and Canada have always had what we've all thought was a special relationship. But as in any relationship, we have either personal or public or in business. They need attention, and they need care, and they need types of things that make relationships thrive and grow. I was a law enforcement official in the U.S. government at 9/11, and I can speak firsthand the shock that it caused within the federal government. And as a resident on the northern border, in northern New York State, I can tell you that the border has certainly thickened. Just by way of an anecdote, in my current position and my previous position, I travel an awful lot and go through customs, many countries. One of the border crossings I fear the most is the border crossing in northern New York, coming from Canada into the United States. It's usually the longest, the hardest, and the most controversial crossing, and it shouldn't be. I quote Tina Turner in that favorite song of hers, where she says, "We can make this nice and rough, or we can make this nice and easy." And I think the U.S. Customs, as an anecdote only, has made things a little rougher than it need be, and things need to look at how they can be made easier. And I only say that as an anecdote. There are many issues that have been discussed here. Trade barriers, border security, regulatory harmonization, cooperation, traffic, regulatory challenges, the use of the Great Lakes. All of these are great issues. But I think there's one of attitude that needs to be seriously challenged. Political leadership, I can speak for our country, but I suspect for both countries, need to understand that this special relationship could deteriorate significantly if serious steps aren't taken soon. I'm very pleased about the two Jims, Jim Peterson and Jim Blanchard, and the possibility that our deliberations here can resonate back in Washington, where some of the views expressed here can be brought forth in a coherent package and delivered both to the legislature and to the executive branch. I know for a fact that if the White House would decide that we're going to make this nice and easy, it would become nice and easy. But that decision does need to be made, going with Don's comments about political appointments, but also just having the point communicated to the heads of the various departments and agencies that we need to look at things we can do. The idea of a customs union, I think, is a very good idea. But also some of these ideas like global warming and others could be joint projects that we could join in on. I'm struck on how others can make this easy. Mike and I were talking yesterday about travel to China. Every time you go through customs in China, you get the opportunity to have instant feedback. How were you treated? And every time you enter China, you get to vote on the level of courtesy that was shown. I had a particular instance in China, and I thought, oh no, this isn't going to happen. I'm thinking of what would happen if it had taken place here. It was treated with courtesy and dignity and professionalism. And I think that is the challenge that law enforcement officials and the executive branch need to understand in this very special relationship. My first visit to the Canada-U.S. Law Institute was a program which the Canada-U.S. border, the longest undefended border relationship in the world, doesn't seem that way anymore. And I think we need to really seriously recognize this as an issue and see what positive steps can be taken to address it and change it, recognizing there are legitimate law enforcement issues. The law enforcement issues shouldn't interfere with all these other very serious things that are on our plate and on our agenda. Thank you.
Thank you very much, Rick. And you know, a lot of us in different capacities have been dealing with this challenge of Canada-U.S. integration, the overall political economy, but I'm inspired by Rick's comment that we, as we summarize all of this and we open this up to your questions, that we paraphrase Tina Turner and ask the fundamental question, which is, what's law got to do with it? Let me turn it over to you and we'll take a few questions. There's a microphone that's roving. We only have one in the field, so it'll take a little bit longer, but if you remind us who you are, to make it easier for the note takers, we'll turn it over to you, David.
I think, David Crane, I think we heard the positive side of public-private partnership from David Fun when he portrayed business as trying to solve problems, and that the initiative of business can be very helpful. But so much of what we see is business trying to prevent problems from being solved. And if you look at the history of automotive fuel efficiency over the last decade, we talk about this grassroots movement in California. The automotive industry used the courts to try to argue that California had no jurisdiction to do this. The lobbyists worked Congress backwards and forwards to prevent any change in fuel efficiency standards. And so this is an example of how, more often than not, the private sector is a barrier to solutions. So we've got to be careful about how we phrase that role in the public-private sector. I remember when they were trying to develop new guidelines for what was considered to be a healthy diet in the World Health Organization. The biggest problem was the United States, because the sugar industry had lobbied so hard that the United States kept on trying to include levels of sugar consumption, which were way above what any other country was advocating. The fight against lead in gasoline, there were so many of these things. So yes, the private sector can do things to solve problems, but in so many instances, it is part of the problem.
Yes, good.
You know, I think that everything you say is quite valid, but I would add one thing on the fuel example. It's true that, and we see it all the time in trade. It's the nature of the process. The entrenched interests want to keep what they've got, and you know, if I can get a tax on my competitor, I'm going to do that. I mean, that is the way. That's the dynamic of trade. But taking your example of fuel efficiency, exactly what happened. What happened was that, yes, the entrenched interests here fought the fuel efficiency for years. And they got their lunch eaten by the Asian producers who, in fact, were actually making those changes. And as a result, what happened? What happened was that, yes, government was behind. The most efficient producers ate the lunch of the non-efficient producers who wanted to use government barriers to keep things the way they were. So that the status quo, even when trying to use government barriers to keep the status quo there, it doesn't always work out that way. So, I mean, I think it's interesting.
Can I just make one comment on that, and I'll get out of the way so I have questions. And that is that I get these daily press notices from the association representing all the foreign automotive producers in the United States. They also lobbied against the California provisions.
No doubt.
Other questions? Yes, ma'am.
Yes, I was glad that you mentioned the notice regarding NAFTA regulatory cooperation. My quick question, and then I'd like to follow up with my statement, is the Institute planning on submitting something to DFATE by the May 26th deadline, identifying opportunities to reduce barriers in a range of issues, including standards, technical regulations, conformity assessment procedures for industrial agricultural products, sanitary, photosanitary measures based on this conference?
Funny you should ask. I think in particular your panel, when Dan was asking questions, give me your 3 best recommendations, I think you know where those recommendations are going to end up. And as Jessica said, the deadline for filing is May 26th. But yes, and the purpose of this panel is to get specific, and the questions and the answers that we had throughout this, throughout the last day and a half are going to end up in concrete recommendations. And we've discussed this process that has been launched by the Department of Foreign Affairs and International Trade. And yes, we will be forwarding our recommendations to them under the banner of the Canada-U.S. Law Institute. And again, I want to thank very much not only the panels, but the questions that elicited very, very clear recommendations from many of the panels, particularly the 3 sopranos.
And then I like the comment on the better sounding tone of NAFTA regulatory cooperation that you all pointed out. And I know that you keep mentioning a customs union. And there have been a number of papers written on this that perhaps you might want to take a look at. One was the 2005 Policy Research Initiative paper, Policy Implications of the Canada-U.S. Customs Union. And then there was a first prize winning paper that has an extensive on NAFTA essays that by Elizabeth Cohen from Concordia University that has an extensive bibliography that lists a C.D. Howell paper from Daniel Goldfarb, a University of Maine paper, a David Dodge paper all on this issue. So I think that's something that you all might want to take a look at as well.
Mike Park's
Because I think
written
you
on
can call
it,
it regulatory cooperation rather than a customs union, and gives you much further down the line as well.
I want to go for the big one, customs union. Get rid of all these silly rules of origin.
The idea of a customs union has been around for a long time, and it was one of the elements addressed during the original free trade agreement negotiations in the early and mid-1980s. One of the problems we get to institutional capacity or lack thereof with a customs union is it means a common external tariff, and somebody has to enforce the rules. And the difficulty, the institutional difficulty is, can you have a common external tariff, let's say a Canada-U.S. common external tariff, with two different enforcement agencies, one in Ottawa and one in Washington? It becomes very complex because one capital might apply the rules in a certain way and another capital might not, and ultimately you come to the challenge of not having a binational institutional mechanism that would regulate and enforce the common external tariff. So that's been one of the, if you like, the conceptual challenges in a customs union. It's a good idea, and I think one that we should continue to look at, but there are those practical barriers.
If I might just add on that, as a trade lawyer, I found in the past when I went to Ottawa and I said, we should get rid of the tariff on this item because I have a client that uses it as an input and it would reduce their manufacturing costs. And by the way, there's nobody in Canada making this. The tariff was here because there was an industry 50 years ago, but we don't make this anymore. And it was a hard sell. There was always one company that would pop out of the woodwork and say, you know, if you get rid of that tariff, we're going to have to close the plant and it'll kill this small village. Something changed in the last year or two in Canada where the Department of Finance recently unilaterally disarmed on a whole lot of tariff items where they said having tariffs on inputs is not in the national interest. And I think you're going to see a customs union is going to develop in that. I think you're going to see a lot of tariffs coming off items simply because in both Canada and the United States, we don't make a lot of these items anymore. A lot of the manufacturing is gone. So I think we're moving in that direction. But I do agree with you. We've got to develop a good buzzword for what we're doing here because the other side has captured the debate on this. This is all about sovereignty and these horrible corporations trying to subvert the public interest, and we have to take the debate back. Thank you.
I just have to add at this point before we come to the next question that one of the famous moments in the Security Prosperity Partnership process, which was all about, in many ways, inspection and regulation and what we could do to streamline our processes, was in a meeting where Condoleezza Rice, our Secretary of State, described the meetings as a series of tedious condominium association issues. And I mark that Jim McElroy has taken us from a condo association to now perhaps talking about a co-op. So that's good. We're making progress. David Fung.
David Fung here. I would just like to say comment on the issue of the recent Canadian Ministry of Finance decision to eliminate duty for imports of productive machinery and manufacturing inputs. I would like to say that the Canadian manufacturers and exporters have taken a major step in supporting that. And some of us who were leading the CME took some hit in the process. Some of our members came and said, well, what were you guys doing? And that's part of the reason why, if you look at how that was rolled out, it was phased in. It was in response to some of those members. But I was elected to be the chair of the CME 3 years ago on that basis. I said that Canada, either we start to go down the road of protectionism and hope to save a few jobs in the short term, or we go for global competitiveness. If we don't see a future. And they elected me as a little guy amongst the GE of this world and IBM or whatever, because they felt that in Canada, that is the road that we have to go. And I'm here today really appealing to my American friends to say that the road of protectionism will be repetition of what happened to the United Kingdom after the Second World War. There's no future for that. And as a neighbor to our American friends, we are so intertwined in terms of our economy. If you don't come along with us to say that we can become globally competitive, and I believe that there's absolutely no reason for any American to feel they cannot compete in the world. We need to hold hands together to go and conquer the world. And as I said, it's not just a military conquering the world. It's a case of us learning over there to manage the Chinese, manage the Indians, manage the Cambodians, and I don't care where the next economy pops up. We should be there to manage them for our own prosperity and for the world's prosperity. So I think that we are very concerned. When I was invited to go to Erie, Pennsylvania to talk about global trade, I was told I cannot talk about global supply chain. And to me, that is an enormous warning signal that if our northern states, border states, are not coming together with Canada, custom unit is not going to work. We have to make sure that we find ways to integrate our economy even better, making the border thinner, using technology without compromising any security, and we are moving forward with experimentation, both in Winnipeg and in Ontario, and I'm talking about CME, sometimes I switch hats along the way, that we want to make sure that our economy will continue to be highly integrated, but we have to stop that cost that is increasing every time we ship across the border. And so I look towards this institute to seriously examine making inroad in using water traffic as a way to make us greener and make also 150 trailer being clear customs with one single piece of document has to be better than having 150 drivers crossing the bridge. And so I think the elements which I hope that we can work with you and with your content and network, and sometimes together with ourselves, with CME, and together with NAM in the United States, that we would push forward in making these things happen. We have learned Washington, D.C. is not the only place that we need to sell. We have learned well now that United States politics is very local, and we have to find ways to reach out to the public and Americans so that the average Americans would come along with us and understand that we are ready and we're able to conquer the world together.
Excellent. Any comments from the panel in response? We have a wonderful opportunity here because normally you end a conference, everyone runs away, but because of the way that Dan has set this up for us, we have lunch. And a lunch conversation is so much more civilized than this sort of panel debate, on top of which I know we have a number of students here, and it's always, the students are quiet when you have these kind of big, intimidating panels, but when you can sit down over a sandwich, the students will chime in with their questions. So this is not the end of the conference, this is the beginning of lunch. And with that, let me turn it over to Dan for logistics. Thank you very much.
Well, thank you, Chris, and for facilitating that session, and to our executive committee members, Rick Newcomb, Michael Robinson, Larry Herman, Jim McElroy, and Don Cameron, as well as Dick Cunningham and Selma Lessenberg, who could not be here. this morning. I've had the privilege in my career to essentially be raised not only by Henry, but by these individuals seated here during my experiences with the Canada-U.S. Law Institute. And I can tell you that whenever we have an executive committee meeting, the spark for this session really came up. The first 15 minutes of every meeting are just these chaps and Selma sitting around talking and kibitzing about what's happening in the state of affairs, and that's the pleasure that we have as an institute for the time being. With that, as on behalf of the Canada-U.S. Law Institute, I offer our heartfelt appreciation to all of our speakers and panelists, not only today but throughout this conference. The record, as we were reviewing some of the same day transcripts, were incredible. Some of the golden nuggets that were pulled out of those and the information that's been provided here. We've had individuals that rescheduled children's birthday parties to be here to give a transfer pricing speech. I know David's flown in from Vancouver and so many others, Bill Manson and others that were coming in from both near and far to participate in this conference. I likewise extend our appreciation to our two founding institutions, the University of Western Ontario Faculty of Law and Case Western Reserve University School of Law, and the faculty and staff that participated in these proceedings. Many of you appreciate that there's a great deal of sausage being made, so to speak, in pulling these conferences together, and I extend our heartfelt appreciation to our administrative team under the direction of our assistant dean, Crystal Taylor, as well as Nancy Pratt, our assistant director, Alice Simon, and Jared Gregory, who have been outside, as well as Tim Lynch, who's been handling our AV throughout the weekend, and our court reporters from Mizan and Service. As I've said in the past, this conference really doesn't happen without the free labor, to put it that way, and that's in the form of our students that have been here, who have been taking notes throughout the proceedings. And while I won't identify them all by name, it's been a pretty nice cadre of individuals that we've had. They are seated here, and again, as Chris mentioned, please, and I encourage you to, and them as well, to engage in dialogue with you. But I would note several in particular that we will be missing as they graduate in just a few weeks. You may notice our institute has a family atmosphere, and when the kids leave, it's almost a sad tear as they will. But Steve Dier, Mandy Keith, Carl Rooker, and Andy Finn will be leaving us to go on to greener pastures, although in this economy, who knows where that may be. So I encourage you, if you do have opportunities, to consider our kids from the Canada, students from the Canada-U.S. Law Institute, as well as the team that will be carrying us forward with Sarah Antonucci, Matt Beckhold, and Alexis Parker, and Christian Sorensen, among many others that have been doing the heavy lifting throughout this weekend, taking folks to the airport in a snowstorm or hailstorm yesterday, among many other things. I just spent the weekend. I'm a good Eastern European boy. I'm one of 42 grandchildren, and we just had Easter, so I think there were 160 or some absurd number of us gathered together. And with my nieces, nephews, and cousins ripping apart their Easter baskets, it didn't dawn on me when many of you received that blue bag that you might not have looked into it. In that blue bag includes a folder with all of our conference sponsors, and without their financial and in-kind support, we could not have hosted this conference. Several in particular for Sam and Travis Trade Advisory Service and the wonderful Lori Tanous for providing. Some of you may have missed the presentation the other day. That black thing is a flip drive, so you flip the little thing out. We've received a number of questions about that, as well as Cliffs Natural Resources, whose logo did not appear, and the Department of Foreign Affairs and International Trade Canada, who's provided both through the Consulates General in Detroit and Buffalo support for this event. And I welcome Dan Kolunzik as well in the back of the room, as you've heard, our friends from Buffalo and Pittsburgh and in that territory as well, for providing support. Also in that little blue bag, you may have noticed there's a lapel pin. And for those of you that are flying, you may want to pull that out of the bag and put that into your suitcase. It came much bigger than we ever anticipated. It has a sharp little point, so we don't know if you're going to go through security with that thing. So you may want to yank that out of the bag before you try it, particularly those of you that are flying back up north and attempting to clear customs. You don't want any incidents coming out of the event. As Chris noted, that's not only the end of our conference and the beginning of lunch, but it's the beginning of the much broader initiative on regulatory harmonization, as well as the new era of our institute with Governor Blanchard and Minister Peterson. Immediately in the wake of this, within the next 48 hours, all of the PowerPoints that you've witnessed will be on the website, as well as a number of the handouts that have been distributed. There will be several press releases, and then, as Jessica noted, And I immediately started looking into my calendar as to when are we actually going to submit this program into the Canada Gazette as we're moving things around. But we do have a number of recommendations that will be coming out of this conference, and all of you certainly will be copied and asked for your advice and counsel in the shaping of those. In conclusion, this is the end of the conference and the start of the new beginning, but I thank all of you, particularly those of you that are here on 1:30 on a sunny Saturday afternoon here in Cleveland, Ohio. I worked in, as I said, the federal court for a long time, and one of my favorite moments of my day was in not writing opinions, but drafting opinions, was you would say, for the foregoing reasons, it's hereby ordered, and whatever the ruling was. So in that vein, I do state, for all of the foregoing proceedings, I now hereby declare this conference adjourned, and we invite you over for lunch. Thank you.
I never attached myself.